Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Welcome to PENDREAM TV. The debate over the Chief Justice removal has taken a fiery turn. Lawyer Edudzi Tamakloe has slammed the leadership of Ghana Bar Association, accusing them of hypocrisy in handling this sensitive national issue. Stay with us as we unpack his bold statement and what it means for Ghana's legal and political landscape.
Lawyer Godwin Edudzi Tamakloe, Director Legal, Emma NDC Amanyuku MPA boss. Na ye no entwetwe enkomo. Mira me moche.
Welcome. Ano me chawo, tiefo nyina nso.
Tiefo nyina ajo na bokodi.
Welcome. I say online here big.
Me ba cho bokodi.
Ah, nyamra de mo gra.
Na no ayi alaya fonka bo mu kom nhyamu na mokọ na sempatre no ko bi.
Yo, welcome. The farmer, no, for you now, so welcome. Now, may the Anthony Kadia, my president, John Mahama. And now,
but I wouldn't baby, mamma, as I want to try.
Is it better?
If you
welcome, Namika say museum affiliates so at the back of Montpellier Mahama say or Shejumadi say some major projects and the big push. Was here and then Buenya Asenia Quine and another major one a year who to after our equine on so under the big push. Why I say almost all the 60 regions, major projects that will be financed and now the Omani Act and the volunteer by the time I will be the 4-year mandate way. Now major projects are and our roads are connecting major towns and cities or Mohano at least to receive massive like nti enra na wa chese jumadi na se Bible no che onyankopon twediampon ebeto entiopa ebuso that why markers are somewhere you know when we say this week a week a more the ama asanteman na that we na ewo kumase we share ahimfo impenifo na ma omuko kumase
na why fiko
o prepare ako when we say some kwaya mamre
din
some kwaya mamre nti dokiye na kosomo yebese ochediampo nyankopon se obese asantemasi kwa makasa sun na when we say Afibia Ghana Bar Association, they have meetings or schedule their friend at the annual conference of the Ghana Bar Association. I feel the Abedani, the center of the arena of everything. Unfortunately, because of some pressing engagements, your counterparts are almost another country every year. Say maintenance and amenyomu and the Enkotahudie intervention.
Oh, I see. Now, enkomo efifiri mu ba ye baako eni se yesi mo akra no judiciary no said abramo ye bias enum de ekọ bayi ene ensem baako amko raise ba ye kra ye se mampani nam tumi so e de yi chief justice na die no enkomo a wotete ye neto se no so mi hu se wa make commentary about ensem bia ekọ so.
Yes, no Kwame, Sebio, what we say of all the professional groups or my Muhano, Ghana Bar Association and Kwana sebi making I can say professional association no said you having a name about the 1992 constitution no. It's only the Ghana Bar Association.
Oh wow.
Yes. The professional association, Ghana Medical and Dental Ghana Medical Association will be only a constitution no more. Ghana registered nurses Omudi Amy teachers Amy but what I say she saw Amy Hono at the end of the day no the said the only professional body said you Omudi Ewum Ghana Bar Association. Na Bar Association in so ye wono. The Akoban say I think no. They are very critical group in our national development. The Kasi critical group your voice said you ye kasa. Tumemufo na eyeden omutie yen. Eti na omutie yen no enina efa mo say at least when mo ye a lawyer for omo kasa. Now, some we are lawyers for no more Casadia, and the LCNTO. And no, Akoba say, Sebi, Manu da Sunas. You know, association. Omo issues say, yeah. Oh,
I want man tell you, what's what issues now, day? Hello. Yeah, produce.
Yeah, Brother, I'm sorry. Sometimes your network is Brother, I mean, was serious marketing background.
Yeah, I'm good to HND marketing.
Brother, I mean, Ejuma Ben, I won't hear that. Oh, yeah, Daniel Kobam.
Yeah, you know, I just not car tire too.
No.
Well, yeah. Say,
after now, me can say, now, I say advocacy. The Ghana Bar Association, engage, you know. No, selective. Now, I didn't see America say, selective. No. Say, Kwame, look, me say, your bar president. Ya mame, Mrs. Ifuagati. Every issues, FR1, the impeachment process under Article 146. And Okasa, I was taken aback. No, I didn't in America say I was taken aback. You see, Assembly. Na Sebu opposition started, and in this case, Minianum MPP for started a particular advocacy. Na a Koba say, me bar president, you see the annual bar conference to echo this opposition narrative of viewer. Na and the say, you use the bar platform, a very respected platform, an esteemed platform for purely politics. If you are sana, you begin to wonder whether conversation bar no edi to gano. Yes, said you a manual semna bar no na say a national interest. They in American sir. Kwame, Article 146 of the 1992 Constitution. And you knew a very, in fact, right from its inception, you're using this constitutional provision.
146, no.
What was that?
146, no.
Article 146. Now, within the SIS Sonko, Okaya, Chief Justice B. Omemuhana, Justice of the Supreme Court, I friend Chief Justice Aban. Okay, no.
Meaning Justice Aban, pa.
Good. Nti maybe by ye Justice Aban say or no na obeye Ghana nyina CJ. Na Ghana Bar Association sebi no more penasem for obvious reason. Nti unim de omo ye. Ghana Bar Association ebe plaintiff. You plaintiff. And now call Supreme Court. The Ghana Bar Association has plaintiff issue writ at the Supreme Court. Now writ now issue at the Supreme Court no. Now essentially they now can say ye Chief Justice ayewo omamu hano. Sebi. On se emfata se obey Chief Justice. Inti issue writ no. Now the essence of the writ say Sebio omenya the Supreme Court to make some declarations. Now the Supreme Court no make such declarations now. Effectively no, it will amount to they pronouncing on the qualification of urban. So invariably no, the Ekwakoba Yinana say urban ain't me ain't now enye Dana ye said your friend ye Chief Justice review. And that was the strategy. Thankfully, the Supreme Court judges are never at that time no. They saw through the action because only the Ghana Bar Association area, all they wanted to do was to get urban removed using the back door. No more person will use Article 146. No more person will use Article 146. There's a one using 146 now. No, that is the only mechanism. That is the only mechanism. And cleverly, no, the Ghana Bar Association, said that a year of reliefs, no, in such a way, say, by the time the Supreme Court will make a declaration on it, the Supreme Court would have pronounced on the suitability or otherwise of urban. And then they would have gotten him removed using the back door. The Supreme Court So the Supreme Court saw through it. And if you listen to the reasoning of Justice Pega, Ajabin, and Co. And they almost say, look, the Ghana Bar Association, being a professional association of lawyers, the creme de la creme in our society, ought to know better. But that aside, Brakwame, I didn't see another raising the issue of selectivity in the sense. Which is say, Mrs. Fuagati, say, we need to have a constitutional instrument on how Article 146 proceedings should be regulated. I'm a form raising argument based on Article 296. Okay. Okay. This constitutional provision, Article 146, Article 296, this is not the first time issues about it have come up in our jurisprudence. Okay, 2018, in fact, from 2017 up to 2018, in a Ghana man penny, Nanado Danko Kufado, but you and Kofobi a petition at the bar say Ghana Electoral Commission chairperson, Yema Me Charlotte say, the late Amadou Sule, any Yema Me Margaret Kennedy, Ye as chairpersons and commissioners of the Electoral Commission. Welcome. And now your man penny answer a source petition with mono. Or the petition no command, your mammy, your friend, Justice or Chief Justice Sophia Akufu. At that time, not only the Chief Justice of the Republic of Ghana. Welcome. Or man penny, Nanado Danko Kufuado answer a source petition. And a mammy, a friend of Charlotte say, a chocrat, command man penny, say man penny. But it's a unsaka petition be. Petition no effort, say you may be. Man penny may say, whoa, get me copies of the petition. Sa me who answer. So be cry to one among the 200 more. Sebi. Na o man penny ne kasa mafo ana o ho no ma ye friend Eugene. or responding to Yamame Charlotte say, or no as Oman Penino, said you, or your conveyor belt. You can't to be a conveyor belt as today. Why not to say, said you post office? On the or check kratom or on check kratom. You know, Yaman say, or better crat and the Akoma Livra.
I'm not for a raising point to say. Sa 146, you know, whereby Mampeni the Kratan Bakoma Council of State. A Council of State in the Kwan, do one and ye and conform minimum. No one will determine prima facie case against no less a person than the Chief Justice, you know. And Kayen for 296, you know, and Kayen was say, baby, but my main can was say. Whereas directing or empowering an public officer to do any act or thing, otherwise applying to him by the designation of his office, C 296 C, sorry, was where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provision of this constitution or that law to govern the exercise of the discretionary power. Next is a hand some penini be yes sir. And nam say one legal person, nay quasi judicial activity na war ye per the 146, you know. It can be 296 C na. The case ye instrument to be and now some can say
Kwame. I want to say Ghana. The constitution is a very beautiful constitution. Almost all the provisions have had the Supreme Court interpreting it.
Okay.
This Article 296, but it has already come out for interpretation. 296C. What happened?
So we have a precedent on that.
Precedent. In fact, when in case in the title,
Dabi,
Eli claim Agbamava. Eli claim Agbamava and the Attorney General of the Republic of Ghana. Nana Asante Bedietu and the Attorney General of the Republic of Ghana. What this case is about?
Debut.
Munche 3, pardon. Okaya, Emra Omampeni, Emma Munche 3, pardon. Santo for me, Echo Supreme Court. Say, Omuntia, say, President Mahama, Ama Munche 3, no. Presidential pardon. Now, what was the argument? Argument omu making yen say, Article 72, Omantoni Ejina so, Edemasa presidential pardon, no. But you that provision, the president may.
Okay.
He may grant pardon or remission. And Omuko make argument say you that decision may no since Omampeni and your judicial officer no. We hear a CI
constitutional instruments okay.
The exercise of his powers under Article 72.
Okay.
But what I hear?
Me too.
It is no. The Supreme Court by a majority decision we send a friend Justice Bennett. Emaye. And Justice Bennett can say you or see the essence of that Article 296C. And then say it is to regulate the exercise of discretionary powers so that the person exercising that power or using that power capriciously. But
yeah.
So the exercise of that power no be fair and candid. Supreme Court say when it comes to that exercise of discretion under Article 72, the president doesn't exercise that power alone. He exercises that power in consultation with, upon the advice of the Council of State. And so to the extent to say, the president power under 72, just as the president power to suspend a person under impeachment proceeding under Article 146, no, as a may, no, the president, to the extent that he takes that decision in consultation with or upon the advice of the
law.
Hello.
How does the 72 relate to the 296C?
And so it is the reason why people have raised this ignorance of 296 is the use of the word may.
Okay.
It will say Article 146 from 8, 9, 10, or say the president may, upon the advice of the Council of State, suspend the Chief Justice.
Okay.
Who is under an impeachment proceeding. So it is the use of the word may. And therefore I raised the issue of 296C. Now, because 296 talks about discretion, the use of the word may appearing in 146, 8, 9, and 10, no, connotes the exercise of discretion. And so to that extent, no, yes, Bakwame.
The framers of our constitution, in promulgating that Article 146, you know, I bring a woman team, the a woman team, say 125, no. 3 no I can't say be me said ye be married the two. See,
please do.
The judicial power of Ghana shall be vested in the judiciary. Accordingly, neither the president nor parliament nor any other organ or agents of the president or parliament shall have or be given final judicial power. Is it a case say? And I'm saying the executive now appointed the Chief Justice. No, it's a massa and basso bit me in one. I hate 125 minutes.
Osha Constitution no more. About the Article 146 no is reserved for some special people.
Sure.
It's a special class of public officers. Now, would my be entire 146 no by now 146 any 1960 Constitution no.
Yes, name.
Inti Emra na Osagipo Dr. Kwame Nkrumah no nyonko bebo pa Chief Justice Kosa.
Akukosa say
Akukosa. Na onene ye very close. Na okaya tell you Adama fio no. Omo treason trial no so kai.
Mekai? Yeah.
Good. Inti treason trial no buy no. Kosa no omo tina case no. Eventually ended up acquitted and discharging them. The narrative then was that Nkrumah was not happy with the acquittal. I think that had to follow. It followed the Kulungugu bombing. But what you say?
Me too, pa.
Inti Ekoba Sano, almost a certificate Dr. Kwame Nkrumah in Saga before Ned.
Sure.
As we moved on with our democracy, no. We felt that there is a way we have to insulate.
Hey, what is it? That's why you know as the first Ghanaian chief, the first Ghanaian Inspector General of Police, Uru Amajiti.
They were all implicated in that Kulungugu.
And no, I have 7 senior police officers.
And they were all deemed to have been part of the conspiracy. It's a black woman. I call Basano. And now, 1979 Constitution, no, and we started these provisions when we were then, so that we can protect judicial officers, so that they can act without fear or favor. But what I say, so these provisions were put in the Constitution deliberately, so as to protect superior court judges. That was the reason. So it cannot be said, a Chief Justice cannot be removed. No. Except that the only grounds under which you can remove that person must only be on 3 grounds. Just 3. Stated misbehavior, incompetence, enabling panel, I won't mean performing the responsibilities as a judge, a superior court, or Chief Justice. But what I say. And so, back to the issue, and I'm reason. So, this introduction of Article 146 was put into the constitution to protect the judge for. Into your friend is security of tenor. But what you say? Security of tenor. Sa unipano. O man penibi said your judgment ibana nini and so like nini njeho. What you think now on kaso judgment here I will give you. I don't like it, and for that matter, I'm removing you. No. Into the Ecoba and say 1992 Constitution with this express provision. Allow way. Back forward to the Ghana Bar Association, Black Army. The Ecoba and say you have a situation where a man another down Kufa Dunsa saw petition for the removal of Yema Charlotte say. Or sete or the ma Mame Sofa Akufu. And a Mame Sofa Akufu making the effort of prima facie determination. So a prima facie case has been determined against Yema Mame Sofa Charlotte say any Amadou Suleiman in a Sebio. Based on that, Omote, the Justice Bennett led committee. There were 5 members of that committee. Justice, now retired Supreme Court Judge Anthony Bennett. Yemame Agnes Duji, now retired Supreme Court Judge, and the late Justice Mafosao. At that time, no, not Justice Anthony Bennett and Supreme Court Judge. Justice Mafosao and Agnes Duji were justices of the Court of Appeal, and 2 other civilians, Abrampa, and 1 other woman. Committee ni Yomejumano. The committee we sent the friend was 3-2. It was 3-2. Justice Benny and the other woman a dissent here. The late Justice Mafusao Agnes Dojini Abrampa. 3. They agree say Saloto say should be removed. President Anado Dankwe Kufado acted on the recommendation of the Justice Bennett Committee by a 3-2 majority. In a Omudi Yemame Saloto say a few. Now, Unima one was said,
Daddy,
this is no buyer, no. And I'm my senior brother, Abdul Malik Kwekubaku. That's one chance here in a Oko Supreme Court. Right, Kwame? Oko Supreme Court, no. Only release are not seeking.
No, I said they release, sir.
With the main kind relief for Keke.
Okay.
Or say that a declaration that in exercising the constitutional functions and duties of the Chief Justice of the Republic, you, under Article 146, Clause 3 and 4 of the Constitution, the Chief Justice exercises an administrative rather than functions and duties of a judge.
Okay.
The Chief Justice, under Article 146.3 and 4, for making prima facie determination now, she is not acting as a judge or a judicial officer.
By a administrative function.
Or your administrative function, an inquiry.
Okay.
And so to the extent he says, send you man won't know administrative and it's discretionary, no. There was the need for a constitutional instrument pursuant to Article 1296C.
Oh, okay. And this was now is the time make
filed this application at Echo Supreme Court. No, now the lawyer, Samson Ladi, Ayenene, in a Supreme Court, a fair assembly. Supreme Court, a fair assembly. Only one may be defended Attorney General. Godfrey Adame.
Okay.
No, a deputy AG. On the 6th of February 2019, in a Supreme Court, at Naso, I was asking.
But he is the same person.
Black Kwame. Assembly bar Supreme Court Nana Godfrey Adame raised preliminary legal objection. What was the nature of the objection?
Hanu was it?
Or say, Saskem na Omodia Base, the Chief Justice, in exercising the powers under Article 1463 and 4, no, on performing judicial function but administrative. And for that matter, there was a need for a constitutional instrument to govern and regulate the exercise of that discretionary. Or say it has no way to invoke the original jurisdiction of the Supreme Court.
Wow.
Yes. Brahami. Or say only Kukubaku and Yagin.
Yes, in another instance he was approbating, another instance he was reprobating.
In the Supreme Court, unanimous decision of the Supreme Court. In fact, I think I have the decision of the Supreme Court.
Yeah, first send him. Yeah, we are.
Maybe I'm messing Yama also.
But you.
It is well, decision now a buy no. In the Supreme Court, I can say case now Abdul Malik Kukubaku Ediabano. It is not a proper case to invoke the original jurisdiction. Brahmame. You know, Mubo Asem Nuguye. You know, Mubo Asem Nuguye. At that time, no, yeah, Ghana Bar Association, Sebi, I issue statement. And Casio, say, ye Saloto say, without a publication of a constitutional instrument, no, it's unconstitutional. In fact, the lawyer who defended the Attorney General at that time, Godfrey Adame, as deputy AG on the back court, able raised that preliminary legal point in a Supreme Court, please, who was the lawyer for Chief Justice Gertrude Tokon now removed? Godfrey Adame. Now, the very way the Supreme Court, Supreme Court, the Supreme Court, yeno. And yano na neye mamijo efuagati. It's now the platform of the Ghana Bar raising that issue. And yano. And yano. So why the selectivity? Why the selectivity in the advocacy? Sebi Saloto say no on your bar. Brahmami, Mr. Bissell, Saloto say no on your bar.
Yeah, me too, pa.
Yeah, Mammy, Loretta Lamptey.
NCC.
Flat boss. Or Mantini, no pursuant to Article 146. And guess who brought the petition for the removal of Loretta Lamptey? Richinyama. Unim Richinyama.
Richinyama, pa. Me am Richinyama.
Progressive Nationalist Forum. On your MPP.
As they say, no. They say, one more supported by Umiano Kamupa.
Wonderful. Miaminia, I will fit and die.
Aha, yeah. Say that you see to the better for you. Yabako.
Yaminti. It's a black woman. So why the basis of this selectivity in the advocacy? Huh? Why the selectivity? The Ghana Bar Association, yes, sir. It creates an impression that they are biased towards a political party. I don't think that is the case. And so the bar also needs some introspection. And I won't do that.
Well. Based on the
it is only when one person is crying that you get involved. Then it becomes selective. Article 146, President Akufo-Addo using an independent constitutional body.
No, Mami so Supreme Court will be the court. Same way there is a precedence. Now, we been found Supreme Court per the unim and departed from their earlier decision.
And Makacho say already the Supreme Court in early claim
Agbamava, okay.
On Article 296, I construe say where the person exercises the power in consultation with, and you see, say, Article 146, when it comes to Chief Justice, the President acts in accordance with or in consultation Council of State. Obviously, in such situation, you don't need a CI.
Okay, you don't need any subsidiary legislation, BR.
Yes.
Okay.
Also, that consultative process clears the issue for being fairness.
Now, any ebasa, any bibi say president be wo ho, na bia won po obi asem a obetimi ayin rather than see ekwe assemblyman ko afiri ho.
Well, I don't know. I'm not smarter than the framers of the Constitution. So that you meet we put the Constitution together, intelligent, experience than they are. I can't that, bro, me.
Oh, okay. If
maybe you see who esteem OKFM platform, so every the Ghana Bar Association for trouble. It shouldn't always be seen as then in opposition by a particular political party. Yes, Anna, it breeds a certain sense of selectivity. It may not be intended.
Okay.
I think we should watch some of these things.
Okay. And the law, what you, Maminya, Namina was ban, will be some say, will be a sending question say. Now they constitution, may require who has some Sibiana, not there be a constitutional.
Yes, and I constitution 101.
Bye. Lawyer Godwin Edudzi Tamakloe MPA boss or Emrenimini Director Legal Ede Emma NDC Amanyoko na.
That's it for today on PENDREAM TV. Lawyer Edudzi Tamakloe's attack on the GBA leadership over the CJ's removal saga is sure to stir serious conversation across the country. What do you think? Is the GBA being hypocritical? Share your thoughts in the comment section below. And don't forget to like, subscribe, and hit the notification bell for more breaking updates. Until next time, stay informed and stay engaged on PENDREAM TV.
PENDREAM TV now, so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.